Hello, everyone. This is Giulio Coraggio, location head of the Italian intellectual property and technology team at DLA Piper. Today, as part of our podcast, Diritto al Digitale, we have a great guest, Andrea Renda. Andrea will introduce himself, but briefly is a director of research at the Center for European Policy Studies. He's also professor at the European University Institute, and it's considered one of the fathers of the legislation on artificial intelligence within the European Union. But Andrea, welcome, and maybe you can give a bit of context of your role behind this AI legislation within the European Union.
Well, thank you, Giulio. Thanks for the invitation. It's a pleasure to be here with you, albeit virtually. Well, the first thing that I can say, if I'm one of the fathers, I hope not to be frustrated, because fathers normally want to become fathers when they give birth, right? Okay. And the AI Act is not born yet, if you wish, meaning we are waiting for anxiously for the finalization of the text. Well, some people would say that since both of us are Italian, that sometimes kids in Italy leave home very late, and this is a little bit what is happening with the AI Act. We're still waiting for the kid to really leave home and started to come of age, if you wish. I've been involved since the very beginning with the preparation of the AI Act. I was one of the members of the high-level expert group. It's an independent group of experts that define the ethics guidelines for trustworthy artificial intelligence between 2018 and 2020. That was an independent expert group appointed by the European Commission. And then I led the study that backed the impact assessment of the AI Act in the years 2020, 2021. The AI Act, the proposal of the European Commission, was presented in April 2021. Since then, I've been advising the rapporteurs in the European Parliament on a variety of occasions, but also became the founder of a Forum for International Cooperation on Artificial Intelligence, together with the Brookings Institution and SEPS, and also the chair of the OECD working group on AI risk, where we put together basically all the emerging frameworks for the regulation or the non-regulation of AI that are emerging around the world.
Yeah, Andrea, this is interesting because everyone has the feeling that the urgency of legislation on artificial intelligence just happened last year. Well, all of a sudden, for those that are not pretty much aware of the AI space, ChatGPT was launched, and everyone got into a situation of panic because we had to put in place some rules. But you say that it's a long wave, it's a long process that started more than 3 years ago, that now should see the light, hopefully.
The process started actually at least 6 years ago at the EU level. In the European Parliament, perhaps in a rather awkward way at the beginning, with this resolution on civil law rules for robotics that really didn't resonate very well with the scientific community. But then with the creation in 2018, so a year later, of the AI Alliance and the high-level expert group at the EU level, we really entered in full swing into the work on defining the risks of AI and then started mapping these risks, in particular the ones related to fundamental rights and safety. But when I led the study for the European Commission on the AI Act, the European Commission asked me, could you map which fundamental rights are actually affected by AI? And already by then, 2020, we had evidence that it was not just the typical discrimination issues with algorithms and machine learning, but it's almost every fundamental right was already affected by AI at the time. Of course, particularly in the US, where algorithms were being used also much more in the public and in the private sector. But that was starting to become an issue also in Europe. So this is why the AI Act took this rather comprehensive view and then started mapping, both for safety and fundamental rights, the potential applications of AI that would be considered either as too risky or unacceptably risky and thereby should be prohibited, or high risk and thereby to be regulated.
Yeah, absolutely. Andrea, during the last few days, I was saying, there was a very strong position by the largest European countries, France, Germany, and including Italy, against the approval of the AI Act. Then in the letter, in the paper they drafted, it wasn't really clear whether they wanted to get rid of the whole AI Act or approve a softer version of it. But basically, they were more keen to have a sort of code of conduct along the lines of what the G7 approved last month, because they expected that over-regulating AI could discriminate European companies, since they're definitely smaller than the US giants within this industry. What is your take? Where are we based on your views?
So Giulio, let me get this straight, because it's a very complicated and very tortuous story, right? Go back 1 year when ChatGPT hits the market. It's November last year. The AI Act is basically ready. There are still some disagreements between the European Parliament and the Council. There are already in the AI Act, in the text, some provisions on so-called general purpose AI systems, which are legally a bit more complicated than the typical structure of the AI Act, which looks at applications of AI that are placed on the market for a specific purpose. Of course, if you have a general purpose AI system, so a versatile one, you have to decide what to do with this. But already there were provisions in there that were slightly different between the Parliament and the Council. What happens then? First of all, a group of tech gurus starts sort of throwing fuel on the fire by saying these new powerful models risk the extinction of the human race. They should be regulated like nuclear weapons. I think this is my personal position. I've said that in conferences and in writing. This was intentional to deviate the attention of regulators and policymakers around the world away from regulation and towards international solutions, codes of conduct, soft law. Even if in some contexts, the likes of Sam Altman were shouting, please regulate us, then when they were coming to Brussels, they were saying, oh, please don't regulate us like this. And so I've seen it's been a very, very complicated moment in which legislators had felt the pressure to accommodate and to introduce rules on so-called foundation models and general purpose AI models inside the AI Act. So reopening the Pandora's box of the AI Act. So that decision was made by the European Parliament in February, not to finalize the text and reopen it, to introduce new provisions. And since we are talking mostly to legal experts here, and for those of you that are experts of the EU ordinary legislative procedure, you can imagine that once the procedure has gotten to the final stage, which is a trilogue, right, where European Commission, Parliament, and Council have to reach an agreement, normally there is no possibility to feed more evidence. So writing an entire new body of rules and provisions during the trilogue without an impact assessment, an evaluation, a consultation, or anything like this, it's a leap of faith. You have to really hope that these people have learned their lesson. So what has happened in all these months? The Parliament, the Council, and the European Commission has started battling over the text of the AI Act in a number of respects. First, there is an outstanding problem and disagreement on whether there should be exceptions to the prohibition to use the real-time biometric identification in public places. And that was to be expected. Many member states want to be able to use for cases, for example, of prosecuting suspected terrorists or missing children or other cases like this. They want to be able to use real-time identification through biometric data. But there is, most importantly, as you were mentioning, Giulio, the outstanding issue of whether one should regulate the likes of GPT or not, even if they are not on the market for one purpose, but they are there to be used by downstream players to then potentially develop high-risk or even low-risk applications. That is the real outstanding issue that has created quite a lot of tension between the European Parliament and at least 3 member states. The tension has reached a level that during one of the trilogue meetings a few weeks ago, members of Parliament have actually left the room by saying, if you want to go this way, this is not something that we are ready to withhold. And so the current controversy is not about the AI Act itself, but it's whether the AI Act should contain regulatory measures on foundation models. And by the way, the ones proposed by the Parliament borrow much from the Digital Services Act, Or whether there should be, by the way, as I in a paper had proposed already over a year ago, there should be the provisions that already exist in the AI Act for low or no risk or limited or no risk AI applications that contemplates a code of conduct, a voluntary code of conduct that would be then vetted by the European Commission, whether these provisions could be extended to the case of foundation models and general purpose AI. So creating a code of conduct under the monitoring of the European Commission without imposing new rules and legislation. And the argument in favor of this is also, as you were mentioning, that this is what the G7 is trying to do. This is to some extent also an issue that is under the attention of the United Nations at the moment, but also in the future, the Global Partnership on AI, the G20, and other international forums.
But just to be clear, according to this approach, we will have general purpose is AI, and foundation models govern just by code of conduct, but then the usage of these technologies in regulated fields, like, I don't know, life sciences, for instance, would have ad hoc provisions in the AI Act, or that would be already covered by the sector-specific legislation, for instance, in relation to medical devices?
Yeah, that's a good question. So this is how, in my view, it should be done. So take it as my view. Normally EU policymakers read what I write, but they don't necessarily follow my view, and that's a good thing. That said, what would happen is there would be a code of conduct. Those providers of AI, they want to use general purpose AI systems or want to rely on foundation models to then develop high-risk applications of AI will be covered by the AI Act.
Okay.
Those that, of course, use any form of technology, including foundation models or GPIs, general purpose AI systems, which has many overlaps between the two concepts, to develop products that are already regulated based on sector-specific regulations. Of course, they would need to comply with that sector-specific regulation. The medical devices regulation, the moment you use software, you're already at a tier 2, second level of risk. So you actually have to be subject to a conformity assessment. And that is where the use of the foundation models will come into play. That's normal. I don't see the reason why foundation models should be subject to upstream regulation in the AI Act. What I would propose is rather what in regulatory terms we would call a sunrise clause, meaning that the European Commission says, this is what I'm putting in place. This is what I had in mind for the AI Act. I would like to see some cooperation along the value chain, meaning if the likes of OpenAI or the Microsofts of the world, they should help downstream providers go through their conformity assessment because they know in many cases much more about their model objects. But I'm going to give you 3, 4, 5 years. So if I see that the foundation models producers and developers do not share information with downstream players, or if the market is too concentrated, or if the market is insufficiently transparent, then I will intervene with actual command and control regulation or any form of, let's say, harder regulation. And this is what we call, it's the opposite of a sunset clause, right? It's a sunrise clause in legislation.
Yeah, because many of the principles within the AI Act are already covered in other general EU legislations, like the transparency principles. So it's not that the artificial intelligence is totally unregulated at the moment. When it's used in regulated sectors, definitely it is regulated. But for instance, another high-risk application would be the usage of AI for credit scoring by banks, insurance companies, and so on. In that case, I understand that we would keep, at least according to your view, the provisions in the AI Act, just removing those that are for general purpose and are not, so like the version commercially available of ChatGPT that can be used for any purpose wouldn't fall within the scope of the AI Act and would have to comply within the with the provisions of the code of conduct. But then when GPT-4 is used for a specific high risk, then the provisions would come into place.
Absolutely.
At least according to the view. So it sounds like a very agitating moment for policymakers. We had the paper of the three main European countries last week, and now we are having very frequent meetings. And then we have the deadline of the 6th of December, because the next and maybe the last meeting of the year of the trilogue is on the 6th of December, which is a very relevant deadline, because if then the AI Act, the agreement on the AI Act is not reaching that meeting, then there will not be anymore the Spanish presidency. And I understand that Spain really wants to have the AI Act approved under their presidency. So what do you think is going to happen during the coming days? Because really the window is very short, and it seems kind of awkward that we've been discussing about the AI Act for 6 years, and then we need to rush at the end.
Yeah, what's going to happen is very difficult to say. If I had to, bet with you on what will happen, I would probably place my my stakes on the finalization of the text by the 6th of December, exactly for the reason that you were mentioning. The Spanish presidency really wants to get this done. The Secretary of State for Digitalization in Spain, Carme Artigas, is even one of the two co-chairs of the United Nations multi-stakeholder advisory group on artificial intelligence. She has a reputation to build and defend, also through the AI Act. But the pressure, hopefully doesn't lead to a breakdown in the negotiations, because if there will be no possibility to compose this agreement, then of course the whole thing will go to the Belgian presidency, and that will be the last chance, because then we have elections, and it could also mean after the EU elections, there will be a new commission, a new parliament. And so if the Belgian presidency doesn't finalize this, first of all, it falls under Hungarian presidency, but also, most importantly, the parliament will not be working anymore. And so the European Commission will not be in place anymore. And so for a few months, we're going to have to press play on the AI Act. This would be the most disastrous of the outcomes, in particular for a European Union that would like to see the AI Act become the blueprint for global AI regulation through the so-called Brussels effect. I think the decision to postpone by 9 months the finalization, well, but a few months at least, the finalization of the text in the European Parliament, and this extension of the agony of the trilogue for many more months has already weakened the EU's possibility to really create the blueprint for future AI regulation. The US and China have already had their say through forms of regulation or mix of soft and hard law. In my opinion, there's a tendency to continue rewriting the AI Act because there are new last-minute developments, something that I called a fear of missing out, if you wish, a FOMO syndrome in the EU institutions is not going to lead anywhere. So one thing that I can say is the following, and I'm putting this in an op-ed that will see the light in a couple of days. It's my optimism is more political than technical, if you wish. We have a tradition here in Belgium, where I live now, that the 6th of December is the day Santa Claus reaches Belgium, coming from Spain, by the way. And brings gifts to the kids, right? So if the Spanish presidency could bring through Santa Claus the gift of the finalized text of the AI Act, that would be fantastic, not only for the Spanish presidency, but also for everybody. And I hope in that AI Act, the EU institutions will refrain to put too many new provisions that have not been analyzed, assessed, discussed with stakeholders in the 7 years, 6-7 years in which this text has been under discussion.
Yeah, I absolutely share your view. The EU had the opportunity of being the first one regulating AI. The US executive order is more a framework rather than actual regulations, because it gives an instruction to the directors of the Ministry of Commerce enacting provisions. But absolutely, if the EU wants to become a champion, a benchmark in regulating AI, in order to have the new AI industry flourishing within the European Union, the process needs to speed up and needs to do it now. Andrea, your comments, as always, have been really insightful, and I thank you for your time. And I will bother you again once the AI Act is approved to see, hopefully is approved, to see your view on how the market is going to react to it.
Very good. Thank you very much. Thanks for having me, and hope then that we will see each other again soon, which means the text will have been finalized in due time.